How to protect your hard-earned assets from going to future ex-spouses of our kids. My name is Michael Pevney. I am an estate planning lawyer. I create estate plans for California families. You can ask an estate planning question in the comments. Follow me, subscribe for more estate planning information. So, many of my clients want to protect their legacy. A lot of it they want to pass on down to children, and they want to protect their legacy from going to maybe people that their kids are currently married to but might not be married to in the future. Maybe if they have kids that aren't even married yet or might be getting married, and maybe they're not crazy about the person that they're going to be marrying at all. This is a very common scenario. Child inherits money, they later divorce, and potentially losing a significant portion of that money to that divorce, to that ex-spouse. Now you might say to me, I know that inheritances are separate property. They're not marital property. It's not community property. Now that is true, and where I practice in California, it's a community property state, but that's still true. But it all depends on how the child, once they inherit that money, treats that property. Do they use it to buy a home without a mortgage on a piece of property that the entire family uses? Do they use the money from that account that comes from that inheritance to pay down the mortgage on a family home? Do they use it for family vacations? Does all of that money just get dumped into one big joint account for the entire family to use? Arguments are, and often are successfully made that they intended by their actions, by their behavior, to convert that money from separate property to community property, thereby not necessarily shielding it or shielding all of it from a potential divorce. And so that's generally how the law works on that issue of separate and community property. I'm sorry, it's the lawyer answer of it depends on the situation. But no matter what the situation is, guess who makes a lot of money on that? Lawyers, right? I'm not a divorce lawyer, I'm not a family lawyer, so I'm not involved in that, but I have seen this from the estate planning perspective and try to help people spot issues and spot troubles ahead. Now, if people want to leave something to their child without any sort of strings attached and let the child do whatever they want with, that's totally fine. I have plenty of clients that put the faith and the trust in their kids. They love their daughter-in-law, son-in-law, and obviously they love their grandkids if there are any, and they don't really care what happens to that money once it's passed on to the child. The child knows what's best to do with it. But if that isn't the case, if that isn't the best situation, and we want to protect against a potential ex-spouse getting money that used to belong to you before you passed away, this is the best way to do it. You set up a living trust, making your child and or grandchildren we set up a living trust, making your child or grandchildren the beneficiaries of that trust, making sure that things can only be used for that benefit of the child, of the grandchild, keeping things in the bloodline, so to speak, and keeping any spouses of any children off of that plan. So that would essentially be the structure of that trust. Now, a trust has three people associated with it. So you have the grantor that sets up the trust, you have the trustee that's in control of the trust, and you have the beneficiaries that benefit from that trust. Now, most people, when they initially set up that trust, they are all three of those people, right? You are the grantor, you're setting it up, you are the trustee, you control everything in that trust, and of course you benefit from that trust. But once you're gone, we need a new trustee and we need new beneficiaries. What it's going to be important to do is to keep the beneficiary different from the trustee. So the trustee controls the money, and the money has to be, you have to determine what the rules of the trust are, the terms by which the beneficiaries inherit things, and it's important that the beneficiary, your child in this case, be different than who the trustee is. Now, who should that trustee be? It can be another child, another relative, a trusted friend, a professional of some kind, and there even exist out there professional trustees. Most banks and financial institutions have their own trust department that takes care of this sort of thing. And what we do is we give that trustee the authority to give whatever amount of money they think is appropriate to that beneficiary. We can put different provisions on it. We want there to be conservative provisions, meaning we want to make sure that the beneficiary is living a lifestyle that is one that is in line with how we want them to live, getting an education, caring for a family, running a business, having a job, staying away from substance abuse, that sort of thing. Or it can be very liberal. And when I say conservative and liberal, I don't mean in a political sense. I mean in a monetary sense. So they can be very liberal, saying, this is my child's legacy. I want my child to enjoy this money, to use it for their benefit and for the benefit of their child. But what we do not want to do is actually put that money under the name of that child. So the third party trustee is going to have the discretion to distribute money to that child or to pay for things that that child wants to pay for, and also potentially grandkids who we want to pay for things, and ensuring that those funds are protected and only used when necessary. And we also want to give ongoing control to this trustee, again, keeping the beneficiary's name off of this money. And when that trustee gets old or even passes away, they can pass on the duties of trustee, who the person in control of that money is. Now, why do we want to do this? So what are some kind of horror story type cases? So avoiding this, if money just goes into a kid's name, here's a situation that can sometimes happen. That money is used for family expenses and is now converted to family or community property. The child now gets divorced and the ex-spouse now ends up with half of that money, and they can do whatever they want with it. And worse yet, here's another situation that can also happen. The child passes away. Your child passes away and they now have a widow or a widower. Everything that child has goes to their spouse, whether they leave it to them in their will or they don't have a will and the state says that everything goes to their spouse. So your deceased child's spouse now has your legacy, your inheritance. Now that spouse goes on to marry someone else, and maybe they have kids with that person. Maybe that new spouse has children from a previous relationship. Maybe they just want to spend all the money on themselves. Maybe they have a long-term boyfriend, girlfriend, and they want to spend all the money on that new partner. And essentially, the money goes to the people that you did not intend it to go to. Maybe it goes to who would be, essentially like stepchildren of your child, step-grandchildren. So oftentimes what we want to do is keep money in the bloodline. So we do not make the spouse of any children a beneficiary of the trust. We only make it be the child or the children of those children or the children of those children of those children. So children, grandchildren, great-grandchildren, we want this money to benefit them. They are the only beneficiaries of this trust. And a trust allows us to have control from beyond the grave. And many people want to do this. Now, obviously, there is some time, some effort spent in drafting this document. You want to have a good conversation with an estate planning lawyer that knows what the heck they're doing and how to create a trust like this that makes sure that we protect children monetarily from divorce in the future. And a trust does a couple of other things as well. If your child has a creditor, if they're bankrupt, if they are going through a lawsuit and have a legal judgment against them, well, the money doesn't belong to them, it belongs to the trust. And so we put very specific provisions in this trust that it is not to be used to pay for any judgment. The child is not the trustee and the beneficiary. Remember, we have a third-party trustee involved here. And so that money is typically going to be protected from, as we say, creditors and predators. We also want there to be some flexibility, and it can be flexible to fit very specific family dynamics, offering both that protection and that flexibility. Always a good idea to speak with a qualified estate planning lawyer in the state that you live. Now, I practice in California. I'm in Southern California, practice all over the state. The community property laws may differ in the state that you live, so obviously consult with a lawyer in your state. But if you are in California and you don't have that estate plan set up, and maybe you have a legacy that you want to protect from a potential future ex-spouse of your child, I know it sounds weird and we didn't even like thinking about that, especially if we've got little kids. You can always set up a time to meet with me for free. You will find the best way to do that in the description. And hopefully in this video you have learned a little bit more about how best to protect your legacy, keeping things in the bloodline, making sure things go to the kids and the grandkids, not a potential ex-spouse, not a potential future spouse of a current in-law, which really sounds crazy. And so I appreciate your time, appreciate your attention. And again, please subscribe or follow me, whatever venue you are watching this on. And see you on the next one.